subdivisions are liable for, quote, injury, death, or loss to person or property. So we start with that. Injury, death, or loss to person or property. That is caused by the negligence of their employees. That would refer, would you agree, to injury, death, or loss?
Correct, I agree.
Okay, that injury, death, or loss is caused by the negligence of the employees and that occurs within the grounds or on the grounds of. Would you agree that it also refers to injury, death, or loss?
So I would argue, Your Honor, that it actually refers to the negligence.
Well, that was going to be my follow-up question, so hang on with me for a minute, because I think that's the only way that you can argue your position under the statute.
I agree with that, and that was I highlighted the statutory code. I was going to bring that up and make that argument that if you put a bracket after the word caused, so injury, death, or loss to a person or property that is caused, put a bracket there, by the negligence of their employees, and that occurs within or on the grounds.
And is due to. So we're talking about the same two things there. And is what is due to. It has to be, doesn't it, the injury, death, or loss?
Again, it's possible, but again, we would argue that, again, I don't dispute that defendants' case law and that the case law that they've cited supports the position that they're making. I would just argue that those cases like Dornau and Vento, those are distinguishable. One, because they didn't involve the specific physical defect exception. And two, because, again, this is a very narrow holding that we're asking the court to make. We're not asking the court to expand all cases.
And so what is the nature of that holding? Like if you were writing our opinion, how would you fit the facts here within the statute that Judge Myers just read to you?
If a physical defect is caused by negligence on the grounds of buildings or used in government functions, as here, if the negligence occurs there, but the injury occurs outside of, and it was foreseeable, for example, a tree limb. These tree limbs are along the road. We didn't get into this in the trial court, but there does appear to be some evidence that the city might have been aware of that. But again, we're at the motion to dismiss stage, so we're not there yet. But the argument would be that because they have a duty anyways to maintain those trees along the road, it's within the scope of foreseeability that people would be injured by that tree if it falls outside of the road. The reason for limiting the liability for governmental immunity would be to, limit unforeseen injuries, unforeseen liability. But here, what I'm asking the court to do with this narrow ruling, it doesn't really impose an additional burden on any governmental defendants. It wouldn't result in any heightened duty. They would have the same duty to maintain the trees and avoid any physical defects, because if it were to fall in the park, there would be liability.
But so what's the best case law that supports the notion that you were making and that I was questioning Mr. Heenan about in terms of the act occurring on the property, but the effect being felt off of the property?
It would be most similar, I think, to the Matthews v. Waverly case where it happened in the parking lot. Again, you could say that, parking lot, whether that's part of the park or not. I mean, that court found that it was. Some parking lots may not be part of a park. It just sort of depends on how county lines are drawn. And again, I think that, we understand defendant's position, and I think it's a well-taken position. It's just this is a very narrow circumstance where, again, Your Honor, like you asked with your question, if the tree falls one way, 5 inches to the left, there's liability. If it falls 5 inches to the right, there's no liability. And again, I don't think that this is, for example, the Vento case, that didn't involve a physical defect. It did involve an adjacent property, but not a physical defect that would, if that Vento case would have been decided differently, I think that would have created additional burdens on municipal defendants. Whereas here, the holding we're asking to take is not creating an additional burden, or really, it's such a narrow circumstance that I don't anticipate that this would happen, honestly, all that often. But it happened here, and we would just ask that for honestly, public policy is the biggest reason that our argument is to make, is that the policy that a negligently maintained tree can fall one way and there's liability, and fall another way and there's no liability.
Doesn't that sound like a question for the legislature and not for the First District Court of Appeals?
Yeah, it could, but the legislature hasn't done anything on it in a bunch of time. And again, I think the jury instruction is instrumental too, because the jury instruction only mentions that the negligence occurred, on the grounds, not necessarily that the injury occurred there. And again, it's well taken, defendant's position in their brief that, sometimes the jury instructions aren't exactly contoured, exactly, how the law is, but I think it's instructive here, the fact that there is no specific mention that the injury must occur on the grounds, that's more so a judicial interpretation of the statute.
So we presume the Ohio Jury Instruction Committee is reading the statute the way you are.
That's my position, Your Honor. So that's all the argument I have. Are there any other questions from the panel?
Any questions? Thank you very much.
Thank you.
Mr. Heenan, you have 10 minutes left if you choose to use it.
Judge Myers, to your point, this court already parsed that statute out in O'Brien, and it clearly said that there are 3 elements. You have to meet all 3 of them. And the second one is that the injury had to occur within or on the grounds of buildings used in connection with a governmental function. That did not happen here.
So your position would be that if something falls off of the courthouse because of a defect and hits someone on the steps of the courthouse, there would not be immunity, but if the person was on Court Street, there would be?
Yes. Yes, that's exactly the same situation we have here. If it landed on the outside on the side, or maybe not on the sidewalk, that's getting into different issues to who would own that. But if it fell
That's
on
why I put it on the steps.
if it fell on the steps, and that is clearly part of the courthouse, part of the courthouse's property, then unquestionably that would be a situation where the physical defects exception would say you do not have immunity.
Just out of curiosity, why would the legislature make that distinction in my courthouse hypothetical?
I think ultimately the exception was designed to make sure that we take care of our buildings and our grounds that we have buildings on. I think they want to make sure that if it was property that was, governmental property in the middle of nowhere that no one ever went to. But when there's buildings, people are going to those on a regular basis for whatever reason, and then we need to take better care of those to make sure that everything's all right.
But then wouldn't Mr. Buckley's interpretation be the correct statutory interpretation then, that the negligence occurs on the property, but the injury can be outside of the property? I understand your argument of why that's not true, but...
And the wisdom of the way it's written can be questioned, and we can talk about it all day, but there have been plenty of cases, I've cited most of them that I could find, where this type of situation has happened. And the legislature is presumably aware of that and has decided that the way things are written is the way they want things written and the way they want things done. And here they very well may look at a situation where there's a roadway and say, we already have a public roadway exception. Why do we need to, expand or create or change what we've already got when we've said what applies to the grounds of a building, and we've got another one that applies for roadways. And even then, with governmental functions, we've got one for tree maintenance. And I realize it can be very intertwined, and that's why, luckily we were able to narrow these issues down to something a little bit easier to hopefully deal with for the court. But these are often hard cases because, as this court has said many times, when immunity happens, somebody has gotten injured and immunity cuts them off. And that is obviously a hard thing to tell that person. But that's what immunity is, and that's what the public policy, that's what the legislature has chosen to do. And it's the legislature can choose to change that if they want to. But at this point in time, they have not. And in this case, under the facts that have been alleged, the city's immune, and the motion to dismiss should have been granted. Unless the court has any questions, I'll just ask that you reverse. Thank you very much.
Thank you. Thank you both very much for your arguments this morning. We will take this case under submission and give you a timely written opinion.
Now that we're not on the case, I will say it's wonderful to be back and see you all.
We feel the same way. The next case on our docket this morning is Meehan versus Mardis. Mr. Thomas is here on behalf of appellant. Mr. Mulvey and Mr. Stolf are here on behalf of appellees. Before we begin, Mr. Mulvey, Mr. Stolf, have you discussed how, or if you want, how you're going to divide your 15 minutes?
Yeah, Your Honor, I would like to take 10 minutes and leave 5 minutes for Dale.
All right, and when we get to that point, I will keep your time and let you know when you're close.
Thank you, Judge.
Mr. Thomas, you have 15 minutes this morning. Would you like to reserve any time for
I'll
rebuttal?
reserve 10 minutes for.
All right, and whenever you're ready, you may begin.
Thank you, Your Honor. At first blush, this might seem like a bland rule case, but I submit that the policies at stake are fundamental to our justice system. On the one hand, we have a liberal amendment policy. We have notions that leave is to be freely given. The rule asks us to allow amendments when justice requires. Rule 1 requires us to interpret our rules in order to effect just results. And the Ohio Supreme Court has said on numerous occasions, in the Peterson case cited in the briefs by most everybody, the policy that cases are to be determined on their merits, not on pleading deficiencies. On the other hand,
with all of that, which I agree with, I think the problem in this case is, I mean, we issued a decision in 2019, and we said, hey, there's no claim here for conversion. And I mean, that should have been a red flag to your client if your client believed there was a claim for conversion, and yet it took, I don't know, a year and a half to make the motion for amendment. So while leave should be freely granted and we do want cases decided on the merits, like, we can't allow parties to just wait, as long as they want, because that then thwarts the other goals that we're about to get to.
Well understood, Your Honor. And we understand the court's obligation to move cases along, and it's a daunting task at times. And during that 13-month period between the decision and the motion, that's on me. I will note that there was a pandemic, and the case itself was not moving along. There were other discussions not relevant here. But with regard to delay is looked at in the case law as a reason why leave might not be granted, and all of the reasons why leave might not be granted are rather judicially made. We've got futility. More than half of the cases that are cited by all the parties in this case are futility cases. They're good for the discussion of the principles, but they really don't speak to this case. Freyer, Graham, Hutchinson, Meador, Solowich, Darby, Fisk, all futility cases. The delay cases really examine, it's really kind of a bad faith, because what we're looking at is the movement seeking to delay proceedings. And there's been no finding of that by the trial court. The only thing we can infer from the trial court's actions is that it relied on the statement of Mr. Horn that, hey, it's been a long time and I'm going to suffer prejudice because I'm out of the case. Well, what the court looks at is undue prejudice. Every decision a court makes on a contested motion involves prejudice to the party that loses. Every decision this court makes will prejudice the party that does not prevail. What we're looking at is undue prejudice.
Well, there is a distinction between, litigating against a party and saying, well, I have a fraud claim, and now I'm going to add a conversion claim. So they've been active in the litigation versus the situation where the party's completely out of the case.
You're right, Judge, and I call those the judo cases, where the person comes in and they plead something, they lose, and then they change horses. To mix my metaphors, I apologize. You got the Karat case, you got the Robertson case, you got the Shaw case, and even Foreman v. Davis. All involve people that lost, and then they tried to switch. And that's not what plaintiff or appellant is doing here. Appellant is attempting to create or to correct a deficiency. And one of the things, and I think Mr. Horn cites in his brief, he quotes a case, he quotes the Karat case, but he doesn't state the full quotation. He says the trial court does not abuse its discretion in overruling a motion to defend when the amendment seeks to add a new cause of action. The full quotation, page 613 of that case, cites where a party is not seeking to remedy an oversight or omission in the original complaint, but instead seeks to set a new cause of action against the defendant. The trial court does not abuse its discretion. The omission is clear. What's being done here is an attempt to remedy oversight on the part of counsel with regard to the allegations, and I would urge the court to recall the Ohio Supreme Court's definition of prejudice.
And Mr. Thomas, I know I'm interrupting you, but you're a little bit past your time. I didn't want to interrupt you mid-sentence, but I'll let you complete that thought, and then you'll be at your time.
Thank you, Judge. I'll finish that thought, and I'll take whatever 9 or 8 minutes it is. I would urge the court to apply the definition of prejudice applied by the Ohio Supreme Court in the Hoover case, which Mr. Martis brought to my attention, and I'm grateful for that. The court found no prejudice because the other party, quote, faced no obstacles by the amendment that they would not have faced had the original pleading raised the defense. That's exactly the case that we have here. There's no prejudice other than the loss of a windfall. Thank you.
All right, and you will have 8 minutes remaining.
Thank you, Your Honor.
Mr. Mulvey, and I'll keep your 10 minutes as close as possible.
Please report, Mr. Thomas, Mr. Stahl. I have a 2012 lawsuit here that Mr. Meehan first filed against my client. That's 9 years before he asked to amend his complaint. In that 2012 lawsuit, he states, John Howard Martis engineered payments of approximately $900,000 to Lonnie Horn for additional supervision in connection with a Marriott hotel project in Atlanta, Georgia in 2008. That's 4 years earlier than the 2012 case, despite the fact that Lonnie Horn was not qualified to do it and does not perform this work. He's had ample time. He had ample time after this court ruled in 2019, and he still didn't attempt to amend his complaint. He's now asking the trial court to throw out your 2019 decision. If you read his proposed amended complaint, it reincorporates everything that his original complaint said, including the claims that this court threw out, including the pre-2008 claims against Lonnie Horn, which this court affirmed. And when this court affirmed it, it kind of said in an offhanded remark, it's too bad Mr. Horn didn't get a good lawyer to represent him, or he would be completely out, because the post-2008 claims against Mr. Horn carry no more weight than the pre-2008 claims carried. And had I been more diligent, he would have been entirely out in 2019. And I think that that's finished. I think that the pre-2008 claims against Mr. Horn are finished. This court affirmed the trial court's grant of summary judgment against Mr. Horn for those claims.
Well, let's go back to where you started with the complaint, because it kind of cuts against you to a certain extent, because from the outset of the case, it was always clear that the allegation that your client was involved in some shenanigans here. And so the legal label might have changed, but where specifically is the prejudice to your client and I understand it's taken a long time, but specifically, where is the prejudice to defending against the amended complaint at this point?
Well, I think that if we're going to give any credence to statutes of limitations on activities that took place in 2008 for which Mr. Meehan wants to bring a new cause of action against Mr. Horn in 2021, then that shows you the prejudice. Doesn't the statute?
But that would be a futility argument. I mean, did you make a futility argument below?
I'm not sure that I can answer that, Your Honor. But the activity that took place in 2008. The lower court granted a motion for summary judgment in 2018 or so, and then this court affirmed that in 2019. And Mr. Meehan's proposed amended complaint seeks to reinstate all the claims that this court threw out. And I just don't believe that there's any rationale for that. And this is also an abuse of discretion case for the trial court below, and many of the cases that Mr. Meehan cited have held that an abuse of discretion case is more than just a mistake. Case am I looking at here? Sorry. One of the cases cited by Mr. Meehan, I can't find the first page here. The Frere Seed case, the court says, in order to have an abuse in reaching such a determination, the result must be so palpably and grossly violative of fact and logic that it evidences not the exercise of a will, but perversity of will, not the exercise of judgment, but defiance thereof, not the exercise of reason, but rather of passion or bias. And in this case, clearly the lower court had ample reason to deny the motion to amend. And I think everybody agrees that the case that we're here on right now is about the motion to amend and not the motion for summary judgment. Mr. Thomas, in his brief, says that even if you allowed the motion, the denial of the motion to amend to stand, that the motion for summary judgment would be suspect, but I don't think that that's the case at all. So I believe that Mr. Horn is prejudiced by the fact that he is completely out of this case. And the amendment that Mr. Thomas wants to bring is to reinstate the entire case, including the portions which this court ruled should be dismissed in 2019, as well as adding a new cause of action against Mr. Horn for conversion. Thank you.
All right, thank you. Are you ceding the remainder of your time to Mr. Stolf?
Yes, Your Honor, thank you.
All right. Mr. Stolf, you've got, do the quick math, but you've probably got about 7 minutes.
And I will not take anywhere close to that, Your Honor, although don't hold me to that. May it please the court, Mr. Thomas, Mr. Mulvey. So this is the second trip that we made here to the Court of Appeals, and Judge Bergeron was on the original panel, so he's fully familiar with the facts of this case, I think, and the prior decisions. This case is all about rules matter. This case has been pending since 2012. Then it was dismissed voluntarily and refiled. It relates to facts that occurred, according to the complaint, that occurred prior to or beginning in 2006. We've been living with this case for a long time. We were on the verge of going to trial with Judge Giz down below when, unlike what Mr. Thomas says, and I put this in my brief, it wasn't because of the COVID pandemic. We were trying to forge out a settlement. We were filing pretrial statements and everything else, and I contacted the court to make sure we were still headed, and that's when we were informed that Judge Giz and the bailiff had a conflict, and they were going to be moving the trial. After that, on the date the trial was supposed to happen, is when Mr. Meehan filed his motion for leave to amend, and it regurgitates everything that went before. The one thing I'd like to point out is Mr. Meehan in his brief recites all these facts. As Judge Bergeron knows, all those facts are based upon an allegation in his complaint, which he submitted a self-serving affidavit that says everything in there is true. If the judge, if your honors want to see what the facts of this case are about and what the hooligans that my client was supposedly perpetrating, I encourage you to read the brief or the report that our expert filed back on June 18th of 2021. That sets forth the facts. And so what we're really here on is the Metters case. The Metters case, which is an opinion of this court, speaks exactly to what we're talking about here. And the Metters case says that where the movant who wants to amend his complaint articulates no rationale for why he didn't move to amend earlier than he did, it's purely within the court's discretion to deny it. And, you know, what both the Metters case and the Turner case we're talking about is these repeated, you know, motions that are granted, denied. You go up to the Court of Appeals, the Court of Appeals issues a decision, it comes back down, and now we're starting all over again. Well, you know, I can tell, I think I can, you know, state with pretty good odds that once this case gets remanded back to the court, trial court, and we have a trial, whenever that might be, I guarantee you we're going to be up here again on a third appeal. And we just want, I know my clients...
We look forward to seeing you then.
Thank you, Your Honor. But my client wants to get this case over with, and we were ready to go to trial, and now all of a sudden we have another appeal. So I just think the prejudice here is clear. And again, I'd ask your honors to follow the guidance put out in Metters, which says he has to explain why. He doesn't offer any explanation why, other than, gee, I guess my counsel just forgot about doing it. And I don't think that's a good enough excuse. That's all I have. Thank you. Any questions or?
Question.
Thank you very much.
Mr. Thomas, you have 8 minutes remaining.
Thank you, Your Honor.
So what about Mr. Stolf's closing point? What was the rationale that you articulated to the trial court as to why you were bringing this kind of 11th hour motion to amend?
Well, let me begin with the case that Mr. Stahl relies on, the Metters case. Again, that's a futility case. That poor gentleman died in a collapsed trench. It was a Cafferty case. Subcontractor wants to sue the owner. They went through summary judgment. There's no active participation. So summary judgment for the owner. Then he tries to do the judo, amend the complaint, and articulate some active participation theory. And the court said, we've got all the facts. There's no way you haven't added any new facts, and your new theory just doesn't pass muster. So it was the idea that it recites the standards and such, but what Mr. Stahl is focused on is mere dicta. It's a futility case.
There are other cases that do say that when there's no apparent reason offered to justify the delay, the trial court is well within its discretion to deny a motion to amend. I think that was Mr. Stahl.
I disagree, Your Honor. I think that's a mischaracterization of the cases. The delay that's examined, the question is, there's two questions. Is the movement doing this for dilatory purposes? And if that's the case, you can deny. There's never been an allegation of that. Should we have brought it sooner? Absolutely. Did we do it to
But
push the
how do
trial?
we know that it wasn't for dilatory purposes if you haven't explained why it took you this long to file it?
Well, I wouldn't jump to an inference of bad faith, Your Honor. My opponents never even argued that. The notion that we did this on the eve of trial is inappropriate because 2 months before there was an order saying there aren't going to be trials in Hamilton County. So everyone knew that when we were doing these statements and such, there wasn't going to be a trial. Trial was months away. And the key thing in this amendment, and I've got to get to Mr. Mulvey before my time elapses, but this amendment did not change anything with regard to the trial preparation. No other witness needed to be interviewed. No other person needed to be deposed. No other document needed to be examined. It was merely, and this gets back to Mr. Mulvey, and I confess, if my pleadings were not clear in this regard, I'm appalled. We are not seeking to undo this court's decision on the statute of limitations. We're not seeking to revive anything that you said was dead. Rather, we are simply saying those claims that you said were alive and legitimate vis-a-vis Mr. Martis and his company are also legitimate to the same extent that we can convince a jury that they're beyond the pale of the statute of limitations under a discovery rule, that they apply to Mr. Horn and his company. We're not trying to revive anything that's under the bridge. We're not reinventing the statute of limitations argument. It's just, and this decision, while we're on that point, and the Lehmeyer case that I cited is really, really on all fours with this. We are not doing anything that undermines this court's decision. As Mr. Horn would tell you, there was no claim in the original complaint that alleged conversion on the part of Mr. Horn. So obviously, there's nothing that this court could have done in the first appellate action that would have affected a claim that didn't then exist. We are now asking to add that claim, which causes him no prejudice whatsoever other than the loss of a windfall. He says, I'm out of the case. I'm prejudiced because I'm out of the case.
Did your proposed amended complaint simply restate the complaint that had already been dealt with, or did you tailor it to eliminate any claims that were no longer viable?
For the purposes of clarity, all I did was add the words "and Mr. Horn" to one paragraph in the conversion claim. That's the.
But then wouldn't, if the amendment had been allowed, then wouldn't the parties have had to answer to claims that were already gone?
No, Your Honor. I think the law of the case makes it clear that that's not a revival of the past.
Well, it's a new pleading, and you're making allegations that have to be responded to. You have to answer the amended complaint.
I would argue that the Court of Appeals in its first decision spoke to the unaltered claims or counts in the amended complaint, and they were not changed. No, Mr. Meehan made no effort to change what had been stricken, and so therefore that concern I don't think is a legitimate one. We certainly never advanced that in seeking leave. We never advanced that as a theory that we were trying to do that or to rewrite what had happened. Now, we respect the law of the case, but the law of the case doctrine does not, as well explained in the Lehmeyer case, does not constitute an impediment to the granting of leave in the trial court in this particular narrow respect.
You have about 2 minutes left.
I'll say for the record that Mr. Horn did not make a futility argument in the trial court. And I'll make a clarifying remark. The interplay between the motion for leave to amend and the summary judgment. The summary judgment is a domino that falls after this. If you uphold the amendment, the decision of the trial court to deny the amendment, then there is no validity to our designation of an appellate issue as to the summary judgment. The summary judgment argument hinges on that the notion that leave should have been granted. I would conclude with Mr. Stolf said it so much better than I could. Rules matter, and the rules that are in question here, Rule 15, Rule 1, and the notions, the policies that have been set forth by the Ohio Supreme Court in every one of these cases. Peterson versus Tedosio is my personal favorite in terms of the way the things are expressed. We want trials on their merits. We don't want windfalls. We don't want pleading deficiencies to my sins to be borne by our client. Thank you very much.
All right, thank you. Thank you, everyone, for your arguments this morning. We will take this case under submission and give you a timely written opinion. That will conclude the oral arguments this morning of the First District Court of Appeals.
Thank you, Your Honor. Court of Appeals, First Appellate District of Ohio.
Sir. Where's that stall? I have got the worst cotton mouth. I don't know what's going on. I think. You should have called me Mr. Stall. How are you, sir? See you.